Welcome everyone to the day 2 of the conference. And the first session for today is on claims management. And in this session, we'll hear from Mr. Prateek Bagaria from Singularity Legal. Welcome, Mr. Prateek, to the conference. I will briefly introduce you to the delegates before we start with your session. Mr. Prateek is partner at Singularity Legal. He specializes in advising energy and resources, construction and infrastructure, and shipping and trading companies. His range of experience include advising clients on international arbitrations, on international mediations, cross-border disputes in India, Indonesia, Israel, and various other geographies. He also acts as a strategic counsel in cross-border investments and joint venture and trade deals. He holds an LLM in International Dispute Settlement from MIDS. Over to you, Mr. Prateek, for your presentation.
Thank you so much, Priyanka. Good morning, good afternoon to everyone, and welcome today to this session on hydropower in Africa claims management. I'm just trying to move my screen. Yes. So in today's session, we are going to discuss claims. Claims are an inherent part of a construction project. Every project comes with its own challenges, both in the sense when the time required to complete the project increases, or when the scope of work which you are required to do increases. And there are several factors which play together in increase in this time and cost. And today's session, what we will discuss is when you are involved in such mega projects like a hydropower project, how do you manage these risks and how do you manage these claims? Now, hydroelectricity power plants have complex structures. They involve large amounts of capital with a long-running construction period. Consequently, they impose uncertainty factors with considerably high risk. Unlike many other projects, a hydroelectricity project requires several moving parts to be built. The dam in itself, the power station, the supply lines, all that requires a lot of work both on the land and otherwise technically. Now, this really creates a need to synchronize the project in a way that it reduces claims and it reduces profits seeping out of the project. Now, to achieve that, what is essentially required is that the construction contract itself operates as a valuable project management tool. Usually, when a new project is being negotiated by the business, the idea is that we need the project for the experience and for the turnover. And usually, terms and conditions are either set by the employer pretty rigidly, or the contractor is shy to negotiate the terms to make things sensible for them in the contract. Similarly, for the employer, at times they have big contractors who they are dealing with unique project building opportunities with. And there is reluctance to make a very clear and elaborate construction contract. Now, that may be something which backfires as a strategy, because it is really important to understand that the construction contract itself is a valuable project management tool. And it should include provisions which facilitate dispute avoidance and claim handling. So what is necessary is that the contract has enough provisions to ensure that a dispute never arises. So before something becomes a dispute, it leads to a logical conclusion. This is called dispute avoidance. And generally, the focus of claims is on dispute resolution. But what is very important is that we don't reach the step of dispute resolution and are able to resolve things at the step of dispute avoidance. And this dispute avoidance can happen if the construction contract is clear and it gives down steps. And then, of course, those steps are followed both by the employer and the contractor or the subcontractor, as the case may be. And this is necessary to prevent the dispute from escalating to dispute resolution. So, what the claims team or what the projects team does in a project and what their role should be is to use the construction contract in such a way that any differences really get over at the dispute avoidance level. So there is no real need of dispute resolution. And effective procedures will ideally lead to early solutions, lower costs, and fewer delays to the project overall. And when I say effective solutions, which I'll discuss in detail in the next part of my presentation, what I mean here is the ability to envisage risk and to address the consequence of that risk within the construction contract. The construction contract gives you the ability to allocate risks between various parties involved in the project. And that risk allocation is something which is essential to ensure that the margins you expect from the contract are achieved, the costs you expected to incur are enough, the finances you raised are in place, and the timeline in which you expected to complete the project is met. Because if the risks are not clear, any of the uncertainties will come and impacting the price or the time, that would lead to a dispute as to who is responsible for that impact on the schedule. So when the project is on a critical path, when there are elements on a critical path in a project, and those elements are interrupted by certain risks, the construction contract comes to the rescue to answer who that risk is allocated to. And if that risk allocation is done within the contract clearly, then of course there are solutions uh, early on. But that's not where it ends. Generally, when the contract doesn't provide you solution, the solution comes in from law, be it common law if you're in an Anglophone part of Africa building, be it OHADA if you are in part of places where that law is applied, or be it written contractual law in other parts, or you may choose English law or French law to govern your contract. Those laws will come to the rescue to a certain extent uh, when the construction contract is not clear. But that is not the ideal situation, because those laws would only help you in the dispute resolution phase. If you are able to get a comprehensive construction contract in place, you would have early solutions for dispute avoidance. And once you have those solutions, it is necessary to manage risks. It's necessary to write uh, what the contract requires to, because failure to do that, failure to manage the risks which are coming in the path of completing the project in time, can lead to significant delay and cost overrun, which may not be attributed to either party, or to at least not, or may be attributed to you or the lacks of you after something is given in the construction contract. And that may lead to higher costs and lower margins. So while the project may be complete and you are able to get experience of a large hydro project, or the employer is able to showcase a large hydro project for its population, we suddenly realize that the costs almost doubled, or the time taken almost quadrupled, and the project has lost its purpose. So it's very important to manage those risks, and it's also important to manage the disputes which arise from those risks. If they are not avoided and they go into disputes, those disputes can lead to high costs, and that can make a dent in the overall margin from the project. So it's also very important to manage those disputes in the eventuality we arise. And I'll again discuss this in the next part of my presentation. Uh, and when I say manage disputes, is not only manage it legally, that is, getting a lawyer and ensuring that everything you do is done in consonance with looking at how you can make the best out of the dispute, but is to also managing the cost of that project. Because one big miss which we often see in these projects is that the dispute phase is generally thought to have been financed from your own book. So what generally happens is when there is a dispute, the construction company or the employer thinks that, look, the only way to finance this dispute is to go to my book, withdraw cash, and to pay the lawyers and the consultants to resolve the dispute. But that's not the case. Like the project can be financed, a dispute from the project can also be financed. It's almost like another project which begins, because the end goal of that dispute is generally to recoup the profits which you would have made from the project. And it requires time, money, and a lot of money sometimes when it is very complex and very high value. And it's necessary to manage those costs. It's necessary to raise appropriate finance uh, to be able to see that dispute through effectively and to ensure that the costs are managed. So this is what I am going to cover today in my presentation. Three parts. First, talking about risks. Second, talking about dispute avoidance. And third, talking about dispute resolution. So moving on to the risks. Now, broadly speaking, in our experience, you can classify the risks from a project into these six categories. The first one, and when we talk about geographies like emerging markets, political risk is a large part of it. And that's the first major risk which we see in projects in Africa, in projects in other parts where we worked in Asia. And that can really impact the overall expected margin or the overall expected cost of the project. Now what are these political issues? One is, of course, in a hydro project, you're harnessing rivers, and there is a debate on who has which part of the river to harness, or how much water could be actually utilized from that river. And disputes regarding those, either in a federal structure between states or in an international situation between two countries, uh, can lead to this dispute and delay with regards to the water itself. And that can create issues overall in the time and length of the project, because resolving those disputes may take their own resolution process. Until that time, the project may be halted. And if mobilization is already done, it could lead to a lot of costs and expenses to the contractor or the employer, whoever is there in that situation. Similarly, political unrests, violent political environment, and when I say political unrest, I use it broadly. It could be organized political unrest, or it could be uh, so-called terrorism today, where violent means are used uh, to convey a political point. Those are pretty nasty on the project profit. And I'll give you an example of Africa. We were advising this client who is building a road project in a part of Africa where their nationality was not accepted by certain people in the community as permitted nationality to do the construction project. And there were warnings issued, and there were uh, notices given to them publicly to say you shouldn't give the project to the people of this nationality, or else there will be consequences. And our clients had to then face a situation where there was a terrorist attack on the construction site. There was a bomb which went off. Several people died in the construction project. Managerial people, people who were from the design team, and that overall disrupted a lot of the time and cost involved in the project. And of course, there was a huge amount of loss of human life. But it didn't stop there. They somehow mustered courage and continued to work, tried to absorb that risk as something which uh, you know they would do to make a statement. And they went through another attack in a few days, losing more men. Now, this brought the project to a grinding halt for a while. And one of the main reasons being the contract did not address how the risk allocation of this situation would work. Would this be something as a known risk? Because the warnings were issued at the time when the tender was being made, and the nominations were announced, and the contractor could have pulled out, but he knew the risks of possible backlash, possible terrorist attacks on his project. And should the employer suffer the loss for this and give extension of time, compensate for loss of life and limb and damage to the project, or should this risk be absorbed by the contractor? Now, this kind of risk, if not addressed in the contract at that time, which it did in our case, could lead to disputes and not dispute avoidance.
Mr. Prateek,
Similarly, change.
sorry
Yes,
to interrupt. Another 5 minutes for your session.
yes. Another way to look at it is, bribery, corruption. Those kind of issues are pretty apparent in projects, which lead to disputes. Then there are technical and operational issues. We've seen projects in Philippines, for example, where there are land silting issues, inherent issues in land construction, which come in later. They lead to disputes. Environmental issues. We've seen these issues in projects, in hydro projects, where approvals are not in place, the project gets stalled for a long time. That leads to a dispute. Social economic issues, where you have an example we have from COVID in Bangladesh, when we're doing a project where you have to mobilize at the time of COVID. And if you don't address that risk in the contract, that leads to an issue. Management issues, you have, frauds, diversions, over invoicing by project managers. Those things lead to an issue. And then, of course, financial issues. Uh, we've seen this in a project in Africa, where there was a liquidation of the employer itself. Those can lead to issues. So how do you address these issues? I think for the pre-dispute avoidance part, it's necessary to do a preliminary assessment, look into the local policies, cultures, and environment, due diligence, obtain required authorization and licenses, balancing international standards with municipal legislation, uh, pragmatism. All factors should be considered, including price risk, not to accept exposure only for winning the bid or awarding the contract negotiations, so having clear outlined scope and obligation, unambiguous terms, balanced risk allocation, right of access to information, identification of reporting lines, force majeure clauses, damage clauses, a detailed contract following international procedures and methods like FIDIC, etc., is necessary to avoid the dispute. Mitigation, parties should work together to mitigate losses on account of anticipated obstacles during the performance of the project, likely like delay in handover, possession of land, disruption of the project. All those things need to be mitigated. Deploying new techniques always work. Today you have drone monitoring and you have automatic reporting of certain power transmissions using the blockchain. Those kind of technologies can help the O&M pretty well. And then, of course, preserving the evidence, documenting everything, sending your letters out, involving consultants early in, so the communications as per the contract are precise. I think those are the best ways to avoid dispute. And so far as dispute resolution is concerned, the few things which are required to be done is to review the claims, grounds, and evidence well in advance, decide where you need to go. Do you need to do an investment arbitration before the International Center of Investment Dispute in ICSID because it's a state involved? Do you need to go to a commercial arbitration? Getting your strategy right, collating your documents, keeping data available, which you have preserved for dispute avoidance, choosing the right method of dispute resolution, reviewing your financial capability, as I said, raising finance for the litigation phase specifically, which is litigation finance, ensuring procedural compliance in order to exercise remedies. So sending your notices, approaching the right forum, pigeonholing. This is very narrow ground at the given time in communication. So when the dispute comes in, it becomes difficult to take another position. So avoid doing those kind of things. And last is, of course, considering interim reliefs like partial payments, injunction on bank guarantee invocation, freezing orders. All these really help in early resolution of the dispute. Just quickly finishing about what we do in this role. Singularity is an Asia and Africa focused international dispute boutique. Since 2017, we've handled over $3 billion in cross-border disputes. This comes from various parts of the world: Bahamas, British Virgin Islands, Cayman Islands, Canada, Egypt, Hong Kong, India, Israel, so on and so forth. Pretty focused on absolute dispute avoidance and resolution as a firm. This you'll see is some of our recognitions as a firm, top ranked in Legal 500 for our innovation in Financial Times, so on and so forth. So far, the experience is concerned, we do high value projects. If you see, this is our EPC and construction experience. This would be road projects, power projects, hydro projects. We also are the oil and gas firm of the year. So very focused on the energy sector in that sense. Litigation finance, as I said, is a big part of the practice. We help project companies raise finance for the dispute part of the leg. These are some of the examples of our work. A little bit about me. I am the partner at Singularity Legal. These are the reviews for my work, and I'm going to share the presentation for people to consider this. These are some of the achievements I've achieved in my time working as an international disputes lawyers. And I think with that, I wrap up my presentation, keeping the time in mind, and open up for questions, if any.
Thank you, Mr. Prateek, for a very informative presentation and for raising some very important points regarding claim management. I will now move on to the questions. So the first question that I have received for you is, do you see risk transfer as a proactive control for claims management?
So yes, I would say that. And I would say first, risk allocation is necessary before risk transfer. I think risk transfer is an issue which would come in when allocation is missing. So the first part of claim management should be risk allocation, which is very clearly done at the time of negotiating the contract. But if it's not done, then when you are in a situation where a risk which is unaddressed arises, then it is important to have solutions to address that risk. One way could be a contractor's all liability insurance. That's a pretty good way to transfer risk to a third party, especially for defaults and defects coming from the project. There is also a risk share with subcontractors or consortium partners, which then is able to transfer risk in a situation which arises. So yes, in summary, I would say yes.
Before we end the session, just a quick question. Yesterday, we heard that the IPPs are facing PPA risk, and there have been cases of PPA renegotiation and payment defaults. So, what are your views on this, and what has been the case, such cases so far that you have encountered, and how does it affect the project lending and financials at the end of the day?
Right. So I think this is a very good question. And again, this is something which happens very often in emerging markets. Uh, One way to, of course, address it when it arises, renegotiation of a PPA gives rights outside the PPA in international law to sue the state in investment treaty arbitration. These are rights given to investors on sovereign guarantees by the state in form of a PPA that there would be certain purchases done. Uh, Investment treaty arbitration is a very effective remedy in these situations where the state is taken out of their home jurisdiction to answer to these arbitrary actions. Uh, so this is one solution we've seen used pretty often when there is renegotiation of transfer prices. So far as the financiers are concerned, I think the financiers have to first understand that risk and not finance on the entire price of a contract at a given time. There is that built-in margin you keep for that possibility of prices being revised. But if the prices are revised, I think the financier has to have good recourse on the contractor himself or the IPP to ensure that they are not fully secured only from the revenues of this project, because they can't do much at that time. It is a bad situation. All they can do is either sue the contractor or wait for the contractor or IPP to sue the government to ensure that the old negotiated contract is in place again.
Thank you, Mr. Prateek, for a very informative session, and we look forward for your participation in our future conferences. Thanks once again for joining us today.
Thank you so much.
Yeah.